Hello and a warm welcome to the Federal. I'm Neelu Vyas. Justice Abdul Nazeer has been appointed as the Governor of Andhra Pradesh, and this coming after 40 days of his retirement from the Supreme Court. Justice Nazeer was part of important judgments like demonetisation, Ram Temple, triple talaq. And since the time this announcement has come, people have been raising allegations that it's a matter of quid pro quo, where it's almost seen as some kind of a Ram Mandir payback. But the larger question is that does this pattern threaten the independence of the judiciary? I'm joined by Justice Govind Mathur, who retired as the Chief Justice of Allahabad High Court. So it's a real pleasure to have you on the Federal. And so my first question to you is that when we see Supreme Court judges being appointed to the gubernatorial posts, of course, this is not unprecedented. We also had Justice Satasibam in 2014 when he was elevated as the governor. But do you think that this trend is really disturbing, coming as it does with all the allegations which we are seeing?
You see, principally, I am not in support of any kind of subsequent engagement of any judge. May he be a High Court judge or the Supreme Court judge. Independence of judiciary is an essential attribute for the rule of law. And it is not only required to be there, that independence should be seen also. People are having great faith in Indian judiciary. If any person immediately after his retirement or demitting office, if he is joining any next office, may it be the constitutional office like a governor or any chairman of any tribunal, I feel it gives a message in public about their earlier working too. I am not having any doubt about their earlier working or the judgments they have given, but a message floats in public at large that yes, it is this subsequent appointment, this is this is a reward for certain judgments given. So it would be appropriate not to avail any such appointments. Some restriction is required by the judges themselves.
Right. But sir, do you think that this factor really comes into play? Because there's a clip of Arun Jaitley, which is quite viral, where he says that, this post-retirement sinecure, sometimes tends to influence the pre-retirement judgments. Do you think that it can happen?
Arun Jaitley, he remained an executive as he was a law minister. So Jaitley Saab would have mentioned this, but I would not like to say that this is just given as a reward of a certain judgments given. To my knowledge, this is certainly, I would not like to say much about this. But yes, a restraint is always required to be there by judges themselves. And I tell you one thing more, this issue was discussed before the Constituent Assembly and even outside the Constituent Assembly when we are going to enforce our constitution, we are going to adopt and enact our constitution. And at that time, Dr. B.R. Ambedkar, who was of the view that this kind of appointments, there is no need for any kind of such a restriction in the constitution itself, as that is given for Comptroller and Auditor General of India. At that time, what was the view? I would like to quote what Dr. Ambedkar mentioned at that time. Dr. Ambedkar mentioned that the judiciary decides cases in which government has, if at all, the remotest interest, in fact, no interest at all. The judiciary is engaged in deciding the issue between citizens and very rarely between citizens and the government. Consequentially, the chances of influencing the conduct of a member of the judiciary by government are very remote.
Right.
Now, this was 73 years earlier.
Right.
Now you will find in every third case, the state is the biggest litigant, government is the biggest litigant. The citizens are mainly in conflict with the government. So I think, number one, till there is no bar in the constitution, the judges themselves restrain from availing any such kind of appointment.
No, but Justice
Number
Mathur,
two,
you're talking about
legislature should
Justice
also
Mathur.
think.
But no, but Justice Mathur, you're talking about a self-restraint. Now, how will that self-restraint come in? It has to be if there is a certain code on a cooling off period. Like many people say that, at least for a year, the judges should not agree for post-retirement posts. So who is going to really bring in this cooling off period? That, okay, till this particular time, you can't accept any posts.
Niluja, I was just mentioning that at the first instance, it is for the legislature to bring an amendment in the constitution. It is the right time.
Okay.
It is the right time to bring an amendment in the constitution. We are required to have a restriction for any further engagement. You see, we are having such provisions for chief election commissioner. Chief election commissioner can't avail any employment. Now I can say that so far as the office of governor is concerned, it is not an employment.
Right.
But you see, for CAG, under constitution, CAG can't hold any office. So same kind of provision can be there in the constitution, and legislature must think about it. Right. Yes, as I mentioned that at that time in 1949, Dr. Ambedkar mentioned that such a restriction is not required as government is not a litigant. Right. But now, after 73 years, government is the biggest litigant. Right. Every citizen is in conflict with the government. And every issue is related to government. Our fundamental rights are against the state. Right. We are required to protect. It is the state that is to protect our fundamental rights, our constitutional rights, our other all legal rights. It is the state that is to protect. So now position has been changed. Now we must have such provision. Right. So far as that the restrainment by judges themselves or some cooling period is concerned, yes, I feel there. If Justice R.M. Lodha, when he retired as the Chief Justice of India, he mentioned that at least for good 2 years, I am not going to avail any kind of engagement. I think first, this cooling period, a judge, he is required to prove himself a person extraordinary in other fields also. Right. So far as judgeship is concerned, that is his background. Right. Otherwise, any second day, you retired within a month, within 2 months, if you are availing some engagement, some appointment, right, that gives a bad message to the public at large. But Justice Mathur, such type of message should not quote in public. May that not be having such appointment. I am having no doubt that the judge will, on his next assignment also, he will impart his duties without any fear and favor. Right. But Justice Mathur, there is a contrary view also. You were talking about the cooling off period. You said that the government should try and bring in amendments, and it's high time that the government starts thinking of some kind of a legal provision for this. But there is a contrary view. I was reading Justice Balakrishnan's statement this morning, where he said that a cooling off period is not logical because you have bodies like NCLT or NHRC. And if you look at their constitution, it requires a judge to be there. So obviously, how long can the government wait? And you will have to appoint somebody who is a judge. So what do you really have to say to this? Then will the cooling off period, you see that chairman of NHRC can be a retired judge, a judge who retired 2 years earlier. We are having number of judges who, and if there is a flow with regard to for this cooling period, then yes, the eligibility would be that only after retirement of 2 years. This amendment can be introduced in other enactments also. As a matter of fact, principally, I am of the view that all these legislations, right, this NHRC, and prior to that, the Legal Service Authority, these all enactments were made subsequent to 1985. Prior to 1985, to my knowledge, in most of the enactments, there was no provision for any kind of appointment for judges. Right. It is only after 1985. And now in every tribunal, judges are there. The judges are not expert of each and every subject.
Absolutely.
Criminalization means experts of that specific subject.
Right.
Now, this enactments, these legislations where the necessity has been made to have a judge there, I don't think that itself is having any logic.
Right.
The other experts are available in service matters. Experts are available in environment and ecology. For NGT, experts are available in
Absolutely.
human rights. Experts are available, and you see, there is a provision in Constitution that it is not only the judges to be elevated to Supreme Court. An eminent jurist can also be
Absolutely.
directly elevated as a Supreme Court judges.
In fact, sir, I was coming to that question that do you, a gubernatorial post is a political appointment. Do you think that the a chief justice or maybe a retired judge should be appointed to the post of the governor? Or should there be a bar on this? Because I was reading an article 124(7), which says that the retired Supreme Court judge cannot plead or act in any court or before any authority in India. So that gives him the leeway to be appointed as the governor or the member of parliament. So do you think that this is...
You see, what I am saying, I am having three limbs. Number one, there must be a constitutional bar.
Okay.
Till constitutional bar is not there, a cooling time should be there. And third, the judges themselves, there must be a self-restrainment. They must not accept this position or any office just to maintain or just to give a message that he or she worked independently, fearlessly, and without any favor. What I'm saying is that may the judge work, and he must have, and certainly must have worked fearlessly without any favor. But now such appointments, these are floating a message about favoritism, about some kind of give and take theory when you accept these appointments immediately after retirement. Right. Some cooling period is required, a self-restraint is required till we are not having any constitutional bar, which can very well be there as that is applicable for CAG.
Right. So the timing does raise eyebrows. That's what you are saying very clearly. And this cooling period has to be brought in.
Yes, certainly.
But so people who say that, this undermines the independence of the judiciary. And there are people who say that there is no harm. Now, why is there a mixed reaction to this? Some people feel that, no, that's perfectly justified. If Justice Abdul Nazeer has been appointed as the governor, there's no harm. While some people are opposing it tooth and nail. So why is there a mixed response to this?
You see, mixed response is for the reason that a message is floating there that the man who was deciding very important cases, a man who was party to a very, very prominent judgment relating to Ram Mandir, then demonetisation, triple talaq, etc. Then a common man thinks that yes, now this is a reward for those judgments. May it not be, but a wrong message is floating, and just to stop such kind of views, such message, it is always better to restrain yourself. A judge is having much more responsibility than any other person to keep the judiciary beyond any doubt and to maintain its independence.
Justice Mathur, do you think that this has become a pattern in the last few years? Because people say that, if it happens once in a while, there's no problem. But if it becomes regular, then if it becomes a regular feature, then that is something which is dangerous. Now, we have examples of Justice Ranjan Gogoi, we have Justice Arun Mishra, now you have Justice Abdul Nazeer. I mean, they have been elevated to positions where there was a lot of criticism after their appointments. So do you think, what is your sense? Do you feel that this has become a pattern? This is becoming like a normal routine in the last few years?
You see, so far as instead of going for any individual, I would like to mention that yes, it is once in a while or a routine feature. This should be stopped. There must be a constitutional bar. Now you see what the legislature has done in number of enactments. After entered this inclusion of Article 323B in Constitution of India, 323A and 323B in Constitution of India, in much back in 1976, we are having number of tribunals. Now, in each and every enactment, there is a provision that the chairman or a member of the tribunal will be a former judge. So each and every judge post-retirement, they are desirous to have such engagements. They are trying to have such appointment because it is a requirement of law. So I think that there must, all these enactments should be amended. There must be a constitutional bar. Yes, now the retirement at the age of 62 or at the age of 65 for judges, I think it should be increased. It should be up to the age of 70 years or 75 years, whatever that may be, because you will find that in England, the age of retirement is 70 years, and in some for some courts, some judges 75 years. In America, for Supreme Court judges, there is no age for retirement. So yes, we must also think now after 73 years, things have been changed. Earlier, you see the age of retirement was 60 years for High Court judges and 62 years for Supreme Court judges. Right. It was increased to 62 and 65 years respectively. Right. Legislature must think to increase this age of retirement, and with clear understanding that post-retirement, no engagement, no employment, nothing doing. Right. You give your services to society in other better ways. Right.
That is quite quite a reform which you were talking about, and we do not know whether the government would be doing it or not. But I want to raise a question about the constitutional bar, which you said that there has to be a mandatory cooling off period, which has to come as a self-restraint also by the judges. But do you think that if the legislature has to bring in these code or rules, what about their political will? Because it's when people say that judiciary is not independent, or the government is trying to control the judiciary amidst allegations like these, would there be a political will on the part of the government to bring a code like this?
You say government will not bring this kind of provision, but when we are talking about legislatures, yes, any member of parliament, he can bring a private bill. People can discuss on it. One thing you will notice, that whenever parliament, whenever Lok Sabha or in Rajya Sabha, there is any discussion about judges or judiciary,
right,
all members unanimously criticizing judges. To the extent that when the NJA was introduced,
right,
without any debate, without any kind of objection, that was cleared, and that law was made without all political groups, all political parties came together.
Right.
But when we want a reform in judiciary, when we want that, yes, this kind of restraint should be there, I think legislatures should come forward. They must discuss in parliament for having such kind of restraint. It would be more appropriate. What I feel that such restraint would be appropriate, but it is for the legislators to discuss in parliament.
Right. But sir, again, going back to what Justice Balakrishnan said, he says that, there can't be a strict rule for a cooling off period. Now, why does he say so? Maybe, he could have a different opinion, but if there is a feeling that there can't be a strict rule for a cooling off period, why do you think he would have said, or maybe why does that kind of an opinion exist?
I don't know why he has said so, but I feel that yes, there can be a specific period prescribed in the Constitution itself, either permanent bar or a cooling off period. Something can be there, but immediately appointment immediately after superannuation, I think this gives a bad message. It floats a wrong message in public at large.
But you feel that it's okay to have a retired Supreme Court judge on the post of a governor? You feel that there's no harm, or
What I say that after a cooling period, meaning thereby you have proved yourself in your social life other than as a judge, then all right, after 2 years, 3 years, 7 years, whatever that may be, if somebody want to appoint you as a governor, utilize your service, all right.
right?
But immediately after retirement as a judge, you are becoming a governor or any other holding occupying any other office. This doesn't give a good message. It doesn't reflect independence of judiciary as required in our society.
Thank you so much, Justice Mathur. Always a pleasure having you on the program. And one appeal to the viewers who are watching the Federal: share this video as widely as you can. Send us your feedback and stay tuned with the Federal.
Subscribe to the Federal's YouTube page for more interesting updates.